class on the subjects of union state list. In concurrent list, both state legislatures and parliament is empowered to make laws on the concurrent list. And one more subjects are there, that is joint list is different from these list. So in a subject not mentioned in any list, that will call it as residuary powers are vested with the parliament. So residuary powers rights are completely make laws on these residuary powers. Residuary items are has power with the parliament only. So the parliament has financial functions also. So parliament is the custodian of the public money. The government can neither impose any tax on the public nor spend the money without the approval of the parliament. So the budget is approved by the parliament every year, as we discussed the money bill. So some electoral functions also there for this parliament. It participates in the election of president of India and also elects the vice president of India. And also Lok Sabha elects its speaker and deputy speaker, and the Rajya Sabha elects its deputy chairman, because chairman will be vice president of India. So the power of removal and also there certain high functionaries may be removed from the office on the initiative of the parliament. It can remove the president of India, judges of Supreme Court, judges of high courts through impeachment procedure for violation of the constitution. And also parliament has the right to amend the constitution. Most of the parts of the constitution can be amended by the parliament by special majority. So certain provisions can only be amended by the parliament with the approval of states. So the parliament cannot changes the basic structure of the constitution, as we discussed in previous class. So if we see the power over executive, the parliament exercises control over the executive through question hour, zero hour, calling attention notice, adjournment motion, etc. The government always takes these motions very seriously, because the government's policies are citizen severely, and they are likely to impact the electorate whom the government would have to face ultimately. So that's what the parliament control executive. So this is the parliament organization, composition, and powers and functions. So if we see the president of India, so the Indian president is elected through an electoral college system. As we discussed, MLAs, MPs election is different. Here the president of India's election is different. It is a system which we mentioned in the Constitution of India. Article 54 says the election procedure of President of India. So if you see, these elections are completely conducted and overseen by the Election Commission of India. So Election Commission of India is the main agency to conduct elections for the President of India. So there is a special provision under Article 54 that what we call it as electoral college. These electoral college is made up of all the elected members. We have to remember that here all elected members only. There are several nominated, indirect elected members are there, but they are not included in this electoral college. Here only elected members of the upper and lower houses of the parliament and elected members of the legislative assemblies of the states and union territories like Delhi, Puducherry, and Jammu Kashmir. So Article 55 says the manner of election of president. Article 56 says term of office of president. Article 57 says eligibility or for the re-election of this post. and 58 says qualifications for election as president. If we see the procedure of this election system, before the voting comes to the nomination stage, when where the candidate intending to stand in the election files a nomination along with signed list of 50 proposers and 50 seconders. So these proposers and seconders can be anyone from the total members of electoral college from the state and national level. So there will be MLAs, there will be MPs. So anyone can support this his nomination. So the rule of securing 50 proposers and seconders were implemented when the Election Commission noticed in 1974 that several candidates, many without even a bleak chance of winning, would file their nominations to contest the polls. Just a second. Please ignore background voices, if any. So so as we discussed, only elected members of Lok Sabha and Rajya Sabha, legislative assemblies of states, legislative assemblies of union territories. So why does not take part in the president elections? Because the following groups of people are not involved, which nominated members to the Lok Sabha, 2 Anglo-Indians, and 12 members nominated by the president to the Rajya Sabha, and also governor will nominate the members to the legislative assemblies and legislative councils, both nominated and where there are bicameral legislatures in the states, so like Delhi, Puducherry, and Jammu Kashmir. So if you see the term of the president's office, once president is elected, he holds office for 5 years. He sits in the office even after the completion of 5 years, given no new election have taken place or no new president has been elected till then. So he can also be re-elected and there is no cap on his re-election. So before completion of his tenure, before 6 months of his tenure, the election commission will issue notice for the new election for the new president. So the president election is held accordance with the system of proportional representation by the means of single transferable vote, and the voting is by secret ballot system. So as we discussed, his tenure is 5 years. Before that, we can removed by his office. There is a procedure called impeachment process. So according to the Article 61, the president can be removed from his office before the expiry of his term only on the grounds of violation of the constitution. So however, the constitution does not define the meaning of the phrase violation of the constitution. So the impeachment process can be started from any house of the parliament by leveling charges against him. So the notice bearing the charges against the president must be signed by at least a quarter of the members of the house. So the resolution to impeach the president must be passed by a special majority, 2/3 in the originating house. So during the process, the president of India has the right to defend himself through authorized counsel. So he can choose to defend himself or appoint any person or any lawyer or Attorney General of India to do so. Attorney General is the legal advisor to the union government. So so he personally or he may send representative to the house to defend himself, those who charged against him. So if we see the powers of the president, he has executive powers. Executive powers means the union executive power of the union is vested in the president. As we discussed, the executive power does not only mean the executive of laws passed by the legislature, but also the powers to carry out the business of the government. So, however, it is evident that president is not free to use his powers. Rather, he acts on the advice of the council of ministers. So, as we said, the parliament, if parliament make any laws, they must send that bill to the president office for his assent. So the executive powers of the president include administrative powers and military powers also. So if we see the executive powers of the president has the power to appoint prime minister of India, other ministers of the union, and attorney general of India, the comptroller and auditor general of India, the judges of Supreme Court, including Chief Justice, the judges of high courts of the states, and the governor of the state, and water board chairmen, finance commission, union public service commission chairman and its members, and joint commissions in case of a group of states, chief election commissioner and other commissioners of the election commission of India, the special officer for the scheduled castes and scheduled tribes, and also commission on official language, special office for linguistic minorities, and also at the same time, the president has the power to remove the attorney general of India, the governor of a state, the chairman or a member of public service commission of union or of a state on the report of Supreme Court, and a judge of a Supreme Court of a high court, or election commissioner on an address of parliament. So this is executive powers of the president of India. If we see the legislative powers of the president of India, he has the power to summon or prorogue the houses of parliament or to dissolve the lower house, and he shall also have the power to summon joint sitting for both houses in case of deadlock between them. As we discussed, in case of any clashes, any misunderstandings between the laws made by the Lok Sabha, at that time the president can call for the joint session, so to clear that clashes between the both houses. And also the president shall address the both houses of parliament assembled together at the first session after each general elections to the house of the people and the commencement of the first session of each year. So, and inform parliament of causes and its summons. So, and also nominating members to the houses, as we discussed too, for the two Anglo-Indians to the Lok Sabha. So for the next time, there will be no chance to nominate Anglo-Indians to the Lok Sabha, and 12 members to the Rajya Sabha to be nominated by the president from persons having special knowledge or practical experience of literature, science, arts, and social service. So, and also he has the right to veto if a bill will not be an act of the parliament, Indian parliament, unless until it receives an assent from the president of India. When a bill is presented to the president after its passage in both houses of the parliament, the president shall be entitled to take any of the following three steps. One is he assent to the bill, he withholds his assent to the bill, and he may in the case of bill other than money bills, return the bill for reconsideration of the houses with or without a message suggesting amendments. So a money bill, in case of money bill, a money bill cannot be returned by president for the reconsideration of houses. So because the money bill is initially introduced in the Lok Sabha with the consent of president only. So for the second time, he cannot hold that money bill for a long period. So if the bill is passed against both houses of the parliament with or without amendment and again presented to the president, it would be obligatory upon to him to declare his assent to it. So there is several types of veto power is there. One is absolute veto, which means refusal of assent to any bill, and qualified veto. The veto is qualified when it can be overridden by a higher majority of the legislature, and the bill can be enacted as law with such a majority vote overriding the executive veto. And another one is suspensive veto. A veto is suspensive when the executive veto cannot be overridden by the legislature by an ordinary majority. And pocket veto is also one of the special power to the president. By simply withholding a bill during the last few days of the session of the legislature, executive can prevent the bill to become law. So he has special power to issue ordinances under the Article 123. So the president has a very strong position in the sense that he has the power to issuing ordinances. In case there is a matter of urgency and law is needed for the particular situation, the president can issue ordinances under the Article 123 of the Indian Constitution. So the ordinance can be promulgated by the president when the houses of parliament are not in session. So the ordinance will have the same effect as of the law of the land. So he has also pardoning power also. He has to grant pardons the persons who have been tried and convicted of any offense in cases where the punishment or sentence is for an offense against union law, offense by a court martial, and sentence of death. He can modify, he can cancel these judgments. So the object of conferring this power on the president is to keep the door open for correcting any judicial errors in the operation of law, and to afford relief from the sentence which the president regards unduly harsh. So, and also he has emergency powers. So as we discussed, there are three types of emergency powers are there. One is a national emergency. At that time, the president also enjoys emergency powers. So in a federal structure, the grip of the union of the state is not so tight. Hence, the constitution framers did provide for the exigencies which may require a tightened grip of the union on the state. So Article 356, national emergency means external threats from the neighbors, and also internal aggressions. At that time, the president can introduce emergency powers. So Article 350 gives the powers to the president for the extension of his rule in the states. So if the president, on receipt of report from the governor of a state or otherwise is satisfied that the situation has arisen in which the government of the state cannot be carried on, and the president may extend his rule to the state. So Article 360 also one of the emergency powers regarding financial emergency. If the president is satisfied that the situation has arisen whereby the financial stability or credit of India or any part of the territory is threatened, then the president can declare financial emergency. So he has some discretionary powers also there. The president can send back the advice given by the Council of Ministers for reconsideration. The president has veto power, also known as pocket veto, by which he can withhold or refuse to give his assent to any bill passed by the parliament. It happened once in 1986. President Gnani Jail Singh withheld the Indian Post Code Post Office Amendment Bill. The president appoints the prime minister is one of the discretionary power of the president of India. So, and also he has the judicial powers. He can appoint chief justice and Supreme Court and high court judges, and also he takes advice from the Supreme Court. However, those advices are not binding on him. According to Article 143, president can takes advice from the Supreme Court, and also he has pardoning power as we discussed And also he has some diplomatic powers in international treaties, in agreements that are approved by the parliament are negotiated and concluded in his name. So he is the representative of India in international forums and international affairs. So and also he has military powers too. He is the supreme commander of three forces. He is acts like chief of army, chief of the navy, and chief of the air force. So we will call it as supreme commander of India. So president will act like that. So if you see, the president of India is the integral part of our constitution of India, and also the parliament. Uh, the parliament actions are in the name of president of India only. So if you see, every government order issued by the uh, union government, the seal will be the president of India. If we see the states government orders, the seal will be in the name of governor of particular state. So if you see any state, including our Telangana or Andhra Pradesh, any state, they will issue orders in the name of governor. Like that, parliament will issue orders in the name of president of India. So the president has the special powers in case of any emergency situations, and also so this is the president of India's syllabus. As part of our syllabus, he has the powers in case of nominal times. He has these normal powers, and in case of emergency, he has three types of emergency powers. So is there any doubts regarding president of India?
Sir,
Tell me.
emergency process that one I explain, sir, again.
Emergency powers.
Oh.
Okay. Emergency powers are three types of emergency powers are there. So one is national emergency under Article 352. Second one is Article 356 President's Rule, and Article 360 financial emergency. Three types of emergency powers are there. If you see, the national emergency can be declared based on war, external aggression, or armed rebellion, which means internal aggressions or internal riots. So the term proclamation of emergency is issued in the constitution to describe such a situation. So here Article 352 says the president can declare a national emergency when the security of India or part of its threatened by the war or external aggression or rebellion. So the president has authority to issue this proclamation for the entire country or for a specific region. So this was inserted by the 42nd Constitutional Amendment Act in 1976. So if you see, there are three national emergencies has been imposed at the time of 1962, 1971, and 1975. 1962 and 1971 due to external aggression, war with Pakistan and Bangladesh, and 1975 due to internal disturbances during Indira Gandhi period. So these only three times we have been imposed national emergency by the president of India. If we see the president's rule, according to 356 article, the president may issue this president's rule emergency if he is satisfied based on the report from the governor of the state, or other evidence that the situation has occurred in which the state's government cannot function normally. In case of there is a lack of majority, the government will, in case of lack of majority, what will happen? The government will lapse from their tenure. So at the time, the president's declaration of emergency in such situation known as proclamation on account of the failure of constitutional machinery. So this is famously known as president's rule. So a proclamation of this nature must be presented to both houses of the parliament for approval, just as a declaration of national emergency must be. So only the president has the authority to revoke the president's rule. So if we see, so many times, more than 100 times, we has been imposed this president's rule in India. So another one is financial emergency. Article 360 of the Constitution empowers the president to proclaim a financial emergency if he is satisfied the situation has arisen due to which the financial stability or credit of India or any part of its territory is threatened in matters of finance. So it is inspired by the Union States National Recovery Act 1933. Under such a situation, the executive and legislative powers will go to the center. These two must be approved by the parliament, just like the other two forms of emergencies like national and president's rule. So financial emergency has never been imposed so far. Since the enactment of the Constitution, the president can withdraw the financial emergency at any time by issuing a new proclamation. So from the till now, there is no financial emergencies happened in our India. So this is the three types of emergency powers. So majorly Article 356 imposed more than 100 times, many states. So there are some criticisms also there. It destroys the federal character of the Constitution, and union executives can become all powerful vis-a-vis the state. It could lead the presidents becoming a dictator. So the financial autonomy of the states could be threatened. So Dr. B.R. Ambedkar in the Constitutional Assembly debate said that Article 356 will be the least used and will be a dead letter. Unfortunately, it is the most used provision among the three, is used a deadly weapon, as we see. So as of now, many times, many times these president's rule imposed by the union government. Is there any doubts? If there is no doubts, I am concluding the session.
Thank you, sir.
Thank you. Thank you for your participation.
Thank you, sir.
Thank you. Thank you all.
Thank you, sir.
Mm-hmm.